All right, we're reconvening our morning meeting and shifting gears a little bit to fish and wildlife issues that have been brought to us by the commissioner. Welcome.
Thank you. For the record, I'm Jason Batchelder, Fish and Wildlife Commissioner. I'm joined here today by General Counsel Hannah Smith, Chief Operations Officer Andrea Shortsleeve, and Colonel Justin Stedman. We may or may not get to all of them, depending on how much into the weeds you'd like to get on this. But essentially, we're asking of the committee a technical corrections bill, which we channeled through Representative Pritchard. We have 4 asks in this technical corrections bill, and I won't do much except wave top them for you, and I'll turn it over to Hannah. But we have an amendment on points and penalties, which is reactive to last year's effort that you all helped us with. We have an ask for a 365-day license option, which would essentially now we're a calendar license, so we're January 1 to December 31st. We'd like to have a option to go 365 days for various reasons. We'd like an allowance to be able to react to the Fish and Wildlife Board's regulations when they create a new law that we don't have an ability to charge a fee for. Like we've experienced recently with the second buck tag, we don't have an ability to charge for that tag yet. And then finally, and most recently, there's an addition to sunset a provision that requires us to create a long-range management plan every so many years, and we don't feel it's necessary any longer. With that, I'd like to turn it over to Hannah and have her go through the language, and then have your questions. And I'm happy to come back if you have anything for me. Thank you so much.
Morning. For the record, my name is Hannah Smith. I'm General Counsel for the Department of Fish and Wildlife. And I believe that the committee has a draft, an official draft that Attorney Showman put together, and I will use that to walk through. The first section deals with amendments to 10 VSA 4502, which are points assigned to fish and wildlife violations. And as the commissioner referenced, this is a technical correction. Often, as our rules are updated, the citations that are included in the statute no longer correctly refer to the violation to which they originally referred. So some of this is just right-sizing the citations to the rules. Some of it is some modification to the points assessed for various violations.
Excuse me, right sizing the statute to the rule?
So that the statute refers to the correct sections of the rule.
Oh, so just linking them correctly. Yeah,
Mhm.
not changing their scope or scale.
Yeah.
Representative.
I'm sorry, I just don't know what to be looking at right now.
It's a little funny. It's, we didn't get it from the department here, or Bradley's put it in our language, which will be helpful. And so Hannah's looking, I guess, walking us through, although what we really need from you all is the details of what you're asking and why. And so it's Bradley's testing draft.
This is draft 1.1. The first revision is page 2, line 13. There's a strike through of the language referring to gun suppressors because gun suppressors are no longer banned. In line 15, the amendment to H excludes, these are violations for which 10 points are assessed. It would exclude shooting from a vehicle. This is being moved to a 20-point violation simply because of the safety risks associated with shooting from a vehicle. In the amendment on page 2, line 19, the underlined and struck through statutory regulatory references are correcting the section references.
Representative Chapin has a question.
Sorry, I guess I'm just gonna need you to explain more about
Like
what you
the
just
why.
said under G and H.
Yeah.
Just, I'm not following you.
Sure,
Like you said gun suppressors are no longer banned.
that's correct. And I can, if I could
Obviously,
also,
need a lot more information than that to understand the situation. Like they used to be banned when, and what was the action that means that they're not banned now.
We actually did that.
That was our last
But
year's
that's,
bill.
still, I think it's valid if you could just
Sorry,
frame it a
I
little
just-
bit more.
Even if it was last year, I forget what we did, so I just need to know the one.
Sure, and
So
I,
more detail.
sure, and I would also ask if Colonel Stedman could add any additional language, since this is largely, these are all law enforcement related amendments that we're proposing. So my understanding is,
Just. Yeah. Just can you talk about the points that you're going from to or taking away? Is that, I don't know if you have that information. It's not absolutely necessary, but it just would provide a bit of context for me.
sure.
Thank you.
The amendments that I am reading through right now are all 10-point violations.
So I would just say, we don't need you to walk us through language that our ledge council has drafted. What we need you to walk us through is what you're trying to do in English and why, and then we can do the law stuff with our council. And so whoever among you is prepared to do that would be the most helpful. That's kind of, that would help us understand your ideas.
Okay, so the why we're striking through gun suppressors language.
Sure. And what the ramifications are for points.
They are, so the use of gun suppressors is no longer banned. And I will turn to Colonel Stedman for elaboration on why that was in here and why it's no longer necessary for it to be in here.
Good morning, for the record, Justice Stedman, Colonel of Warden Service. So there was a law that was put into place that had temporarily allowed suppressors because they had previously been disallowed with a sunset. This committee had allowed that to then be permission for them to become permanent. So there's no reason to have it still listed as something that is prohibited because they're now permanently legal unless a new law is enacted. So that's why we're striking it because it doesn't need to be there.
Yeah. Okay. Thanks.
The previous on line 15, violations of 4705 were all previously 10 points. We're now excluding 4705A and making that a 20-point violation because of the safety risk associated with shooting from a vehicle.
Go ahead.
Sorry, you are already doing that, or you're?
That's what we're proposing. It's
You're asking
so
us to move this from a 10-point violation to a 20-point violation.
correct.
Just the entire thing, shooting from motor vehicles or aircraft, you'd like it to move from 10 points to 20.
Just 4705A.
But I'm not seeing, yeah.
So
What is 4705A?
If I may, 4705 covers shooting from any motorized conveyance. And it covers a variety of things. It also includes shooting from within a certain distance of roads of various classes. So it covers a whole lot of things. We're simply trying to break out the specific act of shooting from within or upon a motorized conveyance. Because in theory, if you pull up in your vehicle, stick a gun out the window and shoot something, you have in no way even attempted to decide if that's safe, look at the surrounding or any sort of other thing. So it seems to be more egregious in our opinion than someone who at least gets out of the vehicle and maybe doesn't get the proper distance off the roadway before they shoot. They're at least more aware of their surroundings. Think of all the blind spots in a vehicle. A whole lot of places you can't see if you're sitting in your vehicle when you shoot at something. So that's the idea of making that asking you all to make that a more punitive action than just someone who maybe doesn't get the right distance off the road.
Representative Logan.
So just to be clear, it's 4705A that you're asking to be made a 20-point violation.
Yes, ma'am, and that'll be later in this because that is the specifics. 4705 itself covers it's A, B, C, D. I think it goes through F, but A is the specific act of shooting from within or upon a motorized conveyance.
See, oh yeah, it's a couple pages down. Thanks.
It would also include someone shooting from a motorboat or something of that nature, like airplanes, snowmobiles, ATVs.
It would include all of those.
Literally it spelled out all of those things. So at some point, maybe shooting from an airplane was an issue. I've never experienced it, but it lists all of those things.
Have you had motorboats?
Oh, yes, ma'am. Yes, ma'am.
Yeah,
And to
Representative.
be clear, Colonel, it doesn't say that an automobile needs to be stationary or it could be moving.
It does not specify.
Compounds.
Yes, yeah, it does not. It's shooting from, I believe it's from within or upon a motorized conveyance, and then it lists out all the motorized conveyances.
Somebody riding down the road.
Yeah.
The next amendment, beginning on line 18, is just a correction to the citations in Appendix 44, which is the fur bearer rule. And we can find that specific language. This doesn't change the assessment of points. It's just correcting to citations.
And I don't want to insult anybody's intelligence, but when the board makes changes, oftentimes the numbering changes, and that's what happens. And this is just trying to correct the fact that the numbering changed in the rule. And this prior to this committee entertaining 4502 last year, this 4502 hadn't been looked at in 7 or 8 or even more years. And so things just got really out of whack. And
Very interesting that we have statutory references to sections of a rule that change. I guess I'm gonna put that in Bradley's bucket to help us understand how common that is, and okay, yeah.
On page 3, beginning line 2, there is a proposed amendment to II, which refers to violations of the deer management rule that have 10-point that are assigned 10 points. So these are specifically we're calling out those violations of the deer rule that should be assigned 10 points. So this would be possession of archery equipment during muzzleloader season, and the novice season, violations of novice season rules, and then antlerless violations. So taking an antlerless deer outside of the WMU for where your tag is assigned.
And if I'm just borrowing from Attorney Smith's language earlier, we're just trying to right size in our estimation, the penalty for the offense. And previously, the way 4502 is structured, the only real tool we had to address someone who violated many of the deer rules was a sledgehammer. And we're trying to just not bring a sledgehammer to a situation that doesn't require it. And that's simply what we're trying to accomplish here. So we've broken out Appendix 37 more into more pieces in order to try and right size that to the particular offenses that are taking place.
Representative Sakowicz.
Yeah, could you just give us a little more detail as to like the kinds of things that are changing and the kinds of things that are staying the same?
Sure. So, for example, taking deer at night or with the use of lights or salt or other methods that have traditionally been viewed as particularly egregious, those are remaining 20 points. However, we issue permits for antlerless deer, and they're done by WMUs. And those units are oftentimes divided by roads or other natural boundaries. And in the past, if you were on the wrong side of the road, it was a 3-year loss of license and 20 points, which is a 3-year loss of license, up to a $2,000, the whole 9 yards for being on the wrong side of the road. Now, there are certainly some instances if you are, miles and miles and towns away where it's clear that you intended to violate, but there are many people who just got on the wrong side of literally got on the wrong side of the road. And so this is trying to right size some of that because there are still other mechanisms by which we can bring a sledgehammer if we need to. This is trying to address the folks that maybe just didn't pay enough attention, for lack of a better word. And it is incumbent upon them to know, but there are folks that it's a fairly frequent violation that we encounter in the fall. It's just people being in the wrong area. And many times there's not a clear indication that they intended that. If that makes sense. I'm not sure but so that's one of the examples of this. I can go through all of these if you want, but that's basically what all of these get to are various parts of the deer rule that we're trying to say, there is a clear ability to unintentionally violate this rule, and we're trying to right size that penalty so that people aren't losing their license for 3 years and the whole 9 yards. I'm not sure if that was.
It's been a great way to start. Orienting us to what you're asking for. I mean,
So yeah, so that's this specific one. Some of them, as Attorney Smith said, are more technical, but a lot of that is what this is. A lot of that is the language that used to exist without boring, said all violations of Appendix 37 were a 20-point violation, and it broke out like 3 exceptions. And so Appendix 37 is 16 sections long. So you're basically, we were applying a sledgehammer to a whole lot of it minus 3 sections. And so we're trying to pull those sections out that don't need that and give wards an opportunity to not just hammer on people when it's not necessary. And so that's throughout this, the bear stuff that Attorney Smith will talk about, the turkey stuff that Attorney Smith will talk about, it's all the same thing. And this is all just a result of years of not coming back to this statute and a number of items changing in the timeframe from when this was last addressed.
how often do the boundaries of WMUs change?
Very rarely that I'm aware of. Not sure that they have, and certainly in my tenure, maybe I shouldn't say that. So I know like K went from K1 and K2 to just K, but that would be changing in favor of people, but the actual main units, I don't believe have changed at all.
I think the board has the ability to reevaluate them every 10 years.
Yeah.
How often do the regulations within those change? That's kind of an annual reevaluation.
Well, so the big game rules are updated on as sort of a semi-formal cycle. So because when we're making changes to regulations, we want enough time to actually collect data to support any proposed changes. So I think the deer rules have been every like 5 years, is similar for the other big game rules. So those regulations are changing on a semi-regular basis.
Representative Chapin.
And then rules are changing and these appendices. So this whole section is saying there's 10 points assessed for basically not following rules that might get changed with some regularity. And so sounds like there might be a need for us to either change the way this is structured or more regularly update the statutes to reflect shifts in rules.
So I think, obviously, I only have the last 2 years to speak about, but this committee has been very gracious in letting us do this. So I think that certainly works in the sense that we can adjust these as they change and bring them to this committee. As Attorney Smith said, they don't 5 years, they're not all changing all the time. And some of the changes don't necessitate us coming back here. It's just a matter of when the statutory language gets so far out of whack that we have trouble entering into the court system because it just doesn't, it no longer works in the sense that we can't reference parts that are covered in this. I'm not sure I did a very good job of explaining that.
Thank you. No, I'm getting it.
Yeah, to the Colonel's point, we'd gotten behind in updating this. And so a lot of these are sort of historical corrections that we're trying to make after we've had a chance to evaluate what an appropriate penalty would be for a particular violation. So yes, in that the revisions to II, there were, as the Colonel mentioned, the majority of violations under section 37, which is the deer management rule, were 20 points. We are pulling out some that should only be 10 points. And on line 8.
Sorry, but it's in there. HH, taking a black bear doing damage is 10.
Yeah.
You can, are you allowed to take a black bear doing damage?
Yes, ma'am. This would be for someone who did it incorrectly. So
It's a funny way of wording it then. If you're allowed to take a black bear that's doing damage, why would it be in the penalty section?
The penalty is what's assigned to any violation of section 4827, which lays out the criteria for when you can take a black bear doing damage.
and I believe that's the language of 4827. So 4502 just copies that language.
Yeah, it's just the type, taking black bear doing damage is the title of 48. So it doesn't go into detail around what that explicit violation is. That would be for the warden to assess in issuing that ticket, you know, whether you'd violated that section of law.
Representative Pritchard.
It's my understanding, I guess maybe, I guess I might be incorrect. I thought there was only one exception for allowing bears to be taken damaging those standing corn with farms.
Oh, sorry, no, sir.
These I know aren't.
Bee-
I know.
Well, you can take bears doing, damaging, bees and breaking into buildings and things of that nature. As with standing corn, you do not have to take preventative measures to try and prevent them from damaging your corn before you're allowed to take them. With other issues like chickens and bees and things of that nature, you have to have at least taken some preventative measures before you're allowed to shoot the bear or to take the bear. Also exigent circumstance, I mean, bear trying to break into your house, you don't have to do anything other than just take care of it.
Doesn't matter how it's posted.
With touche. The sign says bears welcome, then I don't know, we'll have to talk about it.
Root till you try.
On line 8, there is a strike through of the existing language, which refers to feeding deer, which has long established that feeding deer is a 10-point violation. That's only struck through because it is now included in II above. So feeding deer remains a 10-point violation, but it's covered in those 10-point violations associated with the deer rule above. And the new language of SS is the Appendix 7, Section 5.3, which is the taking bear over the annual limit.
And for anybody who's astute, if I may just potentially point this out, Section 9 is actually changing in the new, which is why you don't actually see Section 9 in II. I believe it's 8.5 in the new rule, which gets to the point about how things get out of whack. So that's, we're pre-gaming for the changes that are coming. So we won't have to come back after those changes are made.
And Sakowitz.
I'm I'm a little unclear on line 8, 9, what the actual change is in terms of like the penalty. If there
There is no change to points assessed for feeding deer. That's just being moved up.
Bear management rule.
So taking bear over the limit, was that was 20 points?
So that was a 20-point violation. So there's, with a lot of the fish, well, with most laws, there's multiple ways to address a problem. And so the season allows you to take one bear. So if you take a bear above that, you are hunting outside of the season because you're no longer licensed to do that. That's a 20-point violation. But taking bear over the limit was also a 20-point violation. We have had instances where people, believe it or not, have shot 2 bears and they were confused by the early and the late season and not realizing that it was still a 1 bear limit. And some of them were new to hunting. And so again, this is trying to provide an opportunity to not have to bring a sledgehammer every time a warden is like, they clearly didn't mean to do this. They didn't read properly or whatever the issue is. So this is attempting to give us a slightly less punitive measure to address a problem that is addressed in multiple ways. And hopefully I explained that right. I don't know, or explained that clearly, but it's simply trying, again, back to my earlier statement, is trying to give the wardens an opportunity to not have to bring a sledgehammer to every situation is the best way I can explain that.
Can you just remind the committee about the point system and the relative, because you keep calling 20 points.
Yes, ma'am. Sorry.
Sledgehammer, a little.
I apologize.
Context.
So a 20-point violation carries a 3-year loss of license, a requirement to take hunter ethics course, and typically 20-point violations bring substantial penalties in terms of fine. They're usually $2,000 or more, $2,000 or more fines in addition to restitution. So you could be upwards of $5,000 or $6,000 pretty easily. The remedial ethics course costs $100, and that has to be taken statutorily before you can get your license back. And you also cannot hunt, fish, or trap for 3 years because Vermont suspends all 3. It considers those all one thing. 10 points is a 1-year loss of license. It does not require someone to take the hunter ethics course before they get their license back. It's basically the first suspension that we have. The point system is set up such that any points you get, so we do have 5-point violations, which are not, they are listed in here, but they're not broken out. It just says anything not in here is a 5-point violation. 5 points, 10 points, 20 points, doesn't matter. Those stay on your record for 5 years. So if you have a 10-point violation or if you have a violation, the warden's like, they clearly didn't read, whatever the issue is, here's your 10 points, you take a year off. If you then go out and do something stupid, for lack of a better word, in the next 5 years, you're going to be at a minimum under revocation for 2 more years, because 15 points, I apologize, 15 points is a 2-year suspension. At 15 points, you're also required to take the remedial hunter ethics course. So any points over 10, basically 15 or 20, because we don't really have, our points are either 5, 10 or 20. We don't have any 1s or 2s. Within 5 years of a violation, you're basically guaranteed to have to take remedial ethics and do the whole 9 yards. So that's sort of the breakdown. 10 points is a 1-year suspension, 15 points is a 2-year suspension with remedial ethics. 3 years is 20 points is a 3 years, also with remedial ethics. And that's within a 5-year period.
And 5 points, just 5 points.
5 points is just 5 points, yeah.
Start.
So that's typically your license violations, things that are, very just, I forgot to buy a license, whatever, very, very minimal violations that are, I would say, sort of run-of-the-mill violations, if I don't know if that's the right word, but just very typical things that we run into that are viewed as less egregious, by this body at one time.
So it's been a while since I bought a hunting license, but you used to just get 1 bear tag with every license you bought.
Yes,
So I
ma'am.
have a hard time understanding how someone could get confused that they could take 2 bear.
You get 2 tags.
You get 2 tags now. There's an early season and a late season.
And you get 2 tags.
Well, you have to buy them.
Well, yes and no. So I don't want to confuse this too much, but yes, you can buy them, but also lifetime licenses that were issued prior to the change get 2. It's very confusing. So it is possible to get 2 licenses without actually buying them or intending to buy them. And I'm sorry, I'm going to confuse you. My oldest son's lifetime license was purchased before the change. So when he prints his license, he has an early season and a late season. My younger son was after the change, so he only has a late season because he would have to buy the early season. So there are people on the landscape of Vermont with licenses that have early and late season that did not purchase them specifically for that purpose. And again, for people who intentionally, who are clearly trying to skirt the law, we have the ability to charge them more egregiously. This is simply an attempt to have a lesser go at some of the folks that seem to maybe not just be up to speed as much as they should be.
Representative Sakowitz.
Yeah, just so I'm really clear, it sounds like within a 5-year period, these points violations are cumulative.
Yes, sir.
So whenever you get to a 15 or a 20-point level, no matter how you got there, there are certain
Yes, sir.
lengths of time of revocation of license and fines.
Yes, absolutely.
What's the universe of tickets you all issue in a year?
In terms of numbers,
Yeah.
so I don't know I can tell you it was approximately 9,000 tickets, citations, and warnings last year, but I don't know the individual breakout of what. Typically about 2/3 of that is warnings, so I'm not really good at math, but that's about 3,000 give or take tickets and citations. And that's really, please give me a fair amount of grace in that, because that's pulling off of my head from something I did a while ago.
So sort of 9,000 encounters or, well, tickets and warnings.
Yes, ma'am.
And then, but actual tickets would be something more like 3.
Somewhere around 3,000, yeah. As a general statement, wardens are, I like to say we're pretty decent folks, and we try not to hammer up people. As a general statement, I mean, there's a lot of, but yeah, typically it's about 2/3 of the paperwork is warning versus tickets and citations.
All right, are we moving on?
Sure. The next change is page 3, line 11. These are revisions to the turkey management rule. And again, these were previously 20 points. We are making these specific violations 10 points. The violations refer to the correct shot size being used. What else was this? Oh, this was,
So
let's see.
novice, you got
Novice season violations and taking turkey over the limit, again, over the bag limit for the year. The,
Can you remind us the bag limit for turkeys?
It varies. So in the springtime, it's 2, and in the fall, it's 1. In the fall, it's either sex, and in the spring, it is bearded. I shouldn't say either sex. It's just bearded versus not bearded, because obviously female turkeys can grow beards, so it's just bearded versus not bearded.
and there, I do have one correction to what I said. The novice season and the over the limit were 20 and we're moving them to 10. The shot size violation was 5 and we are moving it to 10. This is really an effort to prevent hunters from, if you're not using the correct shot size, there's an increased risk of the animal becoming wounded but not dying. And we're trying to avoid that. We're making that a more egregious violation to use the incorrect shot size.
Percent of Sakowitz.
If you're over the bag limit, doesn't matter how far over the bag limit you are. So that it seemed like if you were way over the bag limit, that might be a more egregious violation than being slightly over the bag limit.
And you absolutely are, sir. And again, there are ways to address that within the construct of what we have, where this does not limit a ward's ability to take someone who is egregiously violating and treat them more harshly or more harshly is the right word, but to address that adequately with a 20-point violation. Because at the end of the day, 47 or 5, I apologize, basically says you have to be licensed for the season you're hunting in. And you can only do what is prescribed by the season. And so if someone were to shoot 3 turkeys, which can happen by accident, or shoot more turkeys, to your point, if we found someone who shot 4 or 5 turkeys in an outing who clearly intended to violate, we can bring a 20-point citation up against them. We can charge them restitution for every bird. In that case, you're looking at you start moving in on $7,000 or $8,000 potentially. But at the same time, it is very possible to accidentally shoot 2 turkeys with 1 shot because of how they move on the landscape. And it happens every year. Or someone thinks they shot a bearded turkey and they didn't. And there's all those sort of things that, again, our options were limited, and it's either nothing or you get a citation. So this is, again, just trying to bring that middle ground into play for wardens on the ground to have an option.
On line 13, the amendment to section 33, which is the moose management rule. This section 12 refers to legal methods for taking moose, the implement that you're allowed. And it was previously 5. We're moving all of the big game legal methods into 10-point violations. The next one.
So taking a moose illegally is a 10-point?
So this would be, moose have a try that in English, different distance requirement from a road. So for everything else, it's 25 feet, but for a moose, it's 100. So that had been a 5-point violation, and it seemed not reasonable to say that if you shot a deer within 25 feet of the road as the law requires, you get a certain point penalty, 10 points. But if you do it for a moose, you only get 5. So we're trying to bring moose to the same playing field as deer, bear, and turkey.
So it's only to the distance from the road.
Well, there's specific, you have to use a certain size rifle, a bow with a certain draw, which are all the method stuff that Attorney Smith is talking about, like shot size for turkeys and all that. That puts all the big game methods on the same 10-point playing field. Then if you shoot moose over limit or you shoot moose over salt or at night, those are all 20-pointers and remain the sort of more serious violations. But they're method issues where you're just either not using the right caliber gun, not using the right draw strength bow. You're not allowed to use radios. So if someone's using radios, like that sort of stuff, that brings all that to the same sort of, not each animal has the same standard or same sort of requirements, but it makes all of the requirements for all of the big game consistent, which had not existed previously. Some were 20, some were 10, some were 5, and we're trying to make all of the methods 10. So that's what we're doing.
So to that point, the revisions on line 14 are to make violations of the bow and arrow standards a 10-point violation. This requires a minimum arrowhead or broadhead size, again, to prevent wounded animals from being on the landscape. So as the Colonel mentioned, we're sort of lumping these into legal methods. So violations of section 5 are now 10 points. The revision on line 15, violations of 4701. Again, the legal methods, use of gun, bow and arrow, crossbow, legal days, use of dogs. Again, previously 5 points for consistency with these legal methods of take. We're moving this to the 10-point section.
Representative Austin, yeah.
I'm just gonna say that the most I hear from my constituents about hunting is hunting with coyotes and dogs going onto private property. And I'm just wondering, when you say dogs here, what does, I mean, are dogs,
No, so
are people holding people accountable
yes,
for
ma'am.
doing that?
I thought this question, so this statute just says where it is allowed, or basically unless otherwise prohibited, you can use dogs. That's all this says. So it's not specifically speaking to coyotes but like you cannot hunt deer with dogs. So that one is not disallowed, but you can hunt bear with dogs based on the rules that are, and it doesn't say you can hunt anything with a dog. It just says if it's permissible to hunt with a dog, or if it's not otherwise said, it's permissible to hunt with a dog. And that's all that, this is it's like a broad sort of thing. Around methods is not specific to coyotes or to bear or to anything or to birds or anything else.
Right, but the dogs aren't permitted to go on private property.
For the question of this had nothing to do with this, but to your question, the dogs are not, yes, sorry, I just wanted
No,
to
sorry.
break that out. No. So the way the regulation has been changed is that dogs are not permitted to go on posted property. Coyote hound hunters are not permitted to release their dogs on posted property. I think I said that right.
Right, but if a dog is chasing a coyote,
Mhm.
that they're not releasing their dogs. They might have released it on public property or whatever, and it runs onto private property. They have to call the dogs back or something, right?
I have to read the regulation. I apologize. I was not
Okay.
prepared for that question, but I believe you're correct, but I need to reread it and I wasn't ready for that one, ma'am.
Okay. Legislation.
Sorry.
Thank you.
It does actually, though, since we digressed a little, I would say, I have a question about, we've gotten questions about out-of-state hounds and what data are you collecting about those hounds when you're registering them to hunt in Vermont?
Over to you, sir.
I think Hannah's best to answer.
Ma'am?
In terms of so we have the application for hounding for coyotes. And I would have to look back at the rule for the specific, I mean, I have to look back at the rule and get back to you.
Yeah, and not just for coyotes, just out-of-state hound requirements for registering your dogs, and that maybe in-state too, but like the question comes up that we have an obligation to register a dog, show that it has a rabies vaccination, for example, if it's a pet versus I don't even know why they're distinguished. It's frustration for me. But that somehow we've let that go on. I would like to know, I'd like assurances that out-of-state dogs are meeting the same standards we're expected of in-state dogs. And if there's a difference between registered hounds and other dogs people keep at their homes, I'll say it that way.
I'm not aware that there's a difference. I know that the statute, this is a statute that's implemented by, it's a public safety statute that requires all domestic dogs to be registered in the town where they're kept. And that registration requires proof of vaccination.
Mhm.
So any dog that is being used to hunt with should be meeting is required to meet that standard.
So someone's checking the out-of-state dogs?
That I don't know in terms of the state of
I'd have to read the Title 13 statute or
Yeah,
Title
23.
23.
Yeah.
Sorry to digress, just,
No, sorry.
okay.
No.
I think you were now moving to 20 points because you just went through 15, so now you're on the line.
Oh, and line 19, again, this is another methods of take violations. Got it. Yes, we are now talking about 20-point violations. Line 19 is violations of 4702, which is the use of a light. And previously, that involved the 20 points were assessed if you had a firearm on you while you were using a light. This is adding language to refer to muzzleloaders, air bows or rifles or crossbows to be clear that if you also have those implements while you're using a light, that is a 20-point violation.
And that's just consistent with the language that y'all put into 4705 last year to address that. So we're just trying to bring that up to speed. So.
Page 4, this is an amendment to, this is section 7 is the bear management rule. And the strike through is a technical correction. These section numbers are redundant because they're captured in the bear management, the 10-point bear management rules. Except for section 5.3, which is now, that's taking bear over the limit, which was moved to be a 10-point violation. That's all the here.
It just goes back to what I was saying, where it said all violations of the bear regulation. In this point, it used to just say, well, you can see what it used to say. And so hunting without a license, the legislature had determined was a 5-point violation, but the rule in it had that you had to have a license to hunt bear. So it in a way tried to make it a 20-point violation on something the legislature had already said was a 5-point. So again, we're just trying to right size the language in 4502 to match the rule and to match what had been intended. So.
The reference to section 8.2, which is new here, is the requirement that you return to the kill site if a warden asks you. And we are making all of those return to kill site violations 20-point violations. That'll be reflected it's in U below and Q below as well for moose and deer.
Meaning that if you refuse to take the warden to the site.
It will be a 20-point violation. The basis for that being that there is clearly something going on, and we'd like to be able to penalize that appropriately if there's a refusal to return to the site.
And where this comes into play oftentimes is where we're having the discussion about boundaries. So someone will say, well, I shot it in, just because I happen to know the area, I shot it in Pollitt, and that's part of K. And you're like, all right, where? And they name some place. It's like, why don't we go there? And then you go there and there's no indication that anything happened there. It's like, where'd you really do this? Well, I shot it over in Mount Holly or whatever. And that's usually how the story goes when folks that are being egregious. And the reason that folks will do that is they will, in certain WMUs, you can shoot certain types of deer that are legal as opposed to other ones where they're not. It's trying to manage the deer effectively. And so they will have shot the wrong thing for the zone they're in, but they know it's good in another zone. And that's where the 20-point ticket becomes, we want to be able to address those folks.
Representative Sefcovic.
A moment ago, you said that, I think, tell me if I'm wrong, that hunting bear out of season is a 5-point. I don't know, hunting bear without a license is 5-point.
Hunting anything without a license.
Hunting anything.
Yes.
So what does that actually mean? Like, what does that really mean? Does that mean actually taking an animal or?
No, so if you're out in the woods, I'll tell you a very specific, that was specific to me. I was the Burlington warden at the time. And it was the fall and I was driving along a back road that cut through woods. It wasn't really a road, but like a farm track type thing. And I see a guy in camouflage with a rifle. I'm like, hey, what are you doing? He's like, walking. Like, where's your license? I'm not hunting. Me, you're in camouflage carrying a rifle. I'm going to write you a ticket for hunting without a license. Had he shot an animal, then it would have been a much more egregious violation. But I just happened to cross him and he didn't have a license. So that's what that refers to is literally, fishing without a license is the one that is encountered frequently throughout the summer. Just someone decides they're going to go drown a worm for a little while. The warden happens by, you have a license. I'm not fishing. You actually are. And here's your ticket. So that it's not, if they were actually in possession of fish, then it becomes a more significant issue. If they actually take an animal, it becomes a more significant issue. But this is just the person that the warden happens to cross who doesn't have a license at the time. No other nothing else involved there. They're engaged in the quote unquote activity by either being in camouflage with a gun in the woods in the fall or by, with a bobber and a worm or a lure or whatever. But they may not have actually they would not have actually taken anything, or certainly not known to the warden that they took anything at that point.
That's great. Thank you.
Ironically, the judge didn't buy his story either. In case you're wondering.
On page 4, line 4, these are
Listen.
amendments to the turkey management rule. So as mentioned before, previously this was written in an inclusive way. So all turkey violations were 20 points except for the ones that are called out, which you see are now struck through. We've shifted it so that the majority of these violations are in the 10-point section, except for these sections we've called out here as 20-point violations. And these include the requirements for the turkey seasons. There are unique shooting hours associated with the spring season that you're required to comply with. Only shooting bearded turkeys in the spring, that requirement is going to remain 20 points. No use of rifles. What's 6.4s?
I think that is right.
Is that a methods of take?
Yes, it's a rifle.
Yeah, illegal methods of take are 20 points. So
Also a target, obviously a shotgun has an effective range of maybe 80 yards. I mean, a rifle has an effective range of 300 yards. So folks doing hunting turkey with rifle are clearly trying to take advantage of the situation. So that would be a far more egregious than, oops, I just accidentally didn't use the right whatever. So. Whoops.
Line 7 is, and again, pulling out the specific moose violations that are now 20 points. This is the moose return to kill site. Is violation. And the amendments on line 12, similar to moose and turkey above, we've shifted the majority of these violations of the deer management rules to 10 points, except for the ones that are called out here. So these refer to methods of take, can't carry a rifle during muzzleloader season, legal methods during archery season, possession of a handgun but cannot use it, the return to the kill site for deer, and the use and baiting. These are all 20-point violations. And then,
Where we started.
sorry, yeah, yes, and this that last amendment, line 17, this is where we've moved 4705A from a 10-point to a 20-point violation, shooting from a motorized vehicle.
You may.
Can you shoot from a drone?
No, you can't
And
use
is
drones.
that under here? Is that assumed?
It would be a motorized conveyance.
It would, yeah.
There's also a specific section, appendix that prohibits the use of drones, and I cannot pull it up out of
It's
my brain
okay.
for you, but
No,
yeah, no.
sure.
They're not permissible for any. So the definition of hunting is very broad, and so they're not permissible even in recovery at this point, just because of the way the language is used and because of, I mean, the technology is advancing so fast. It's insane. And the capabilities that they have are crazy.
Yeah.
So no, that was a long answer. Sorry.
What about other types of remote hunting from a game camera?
So There, set guns and things of that nature are specifically called out, but game cameras are not. So a set gun is literally something set that is triggered remotely. But as far,
Legal?
no, but game cameras are not specifically called out. If there was a method of take associated with the camera, then that would be an issue, but just the cameras itself themselves are not called out anywhere. I don't know if I answered that correctly.
Yes.
I mean, answered it. So-
Is there a method of take associated with cameras? Because I had heard there was starting to be.
No, method of take associated with camera. I think that the only thing I can think of is so a cell camera that sends notifications when something has been in front of it, but it doesn't. I mean, in theory, you still have to get to wherever it is. We have not specifically addressed those in statute anywhere that I'm aware of, or in rule anywhere that I'm aware of.
That's the extent of changes to 4502. The other changes are a little bit more straightforward. The section 2 of the bill proposes a change to section 10 VSA 4263, which deals with issuance of licenses. The proposed change, this is on page 5, line 5. Currently, all annual licenses expire on December 31st of the year for which they were issued. Our proposed language would be to allow the department the option of issuing a license for 365 days from the date on which it's issued. I think that the objective here is primarily related to fishing licenses. We have a lot of folks who are sort of hesitant to buy a license if it's later in the year, knowing that it'll expire in a couple months. And so they might buy the 1 day or whatever they might not buy a license. But if we can issue a license for 365 days, there's just more consistent purchase of licenses.
You don't know that because we haven't done it.
We haven't done it here, but that's been the case in other states where they've allowed for the 365 day rather than the calendar year license issuance.
And that's not going to create another layer of chaos for enforcement?
Well, the way that this is worded, it gives the commissioner the option because we do recognize that there may be enforcement issues that we would need to look at internally. And I think we'd only really look at this for fishing licenses. Because yes, it would require that we more clearly identify on the license that you get. If it's a combo license, it would have to identify that the hunting license expired, for example, at the end of the calendar year, the fishing license expired on another date. So logistically, yes, we would have to deal with those issues. So we're not mandating that any particular licenses be issued for 365 days. The proposed language would give the department the option if we determine that that would be both appropriate and we would be able to administer it. Section 3 of the bill is a revision to section 10 VSA 4255, referring to license fees. This section establishes the fees for the licenses and tags that the department currently administers. The proposed language, which begins on line 14 of page 6, would allow, if the board determines it's necessary to issue additional tags that are not otherwise identified, it would allow the department to assess a fee of up to $40 for those food tags or permits. And this came up again, as the commissioner mentioned, when the board amended the rules last year to allow for a second buck tag. There's no fee in here for a second buck tag. This language would allow us to charge a fee when we issue that tag.
Representative Zakovitz.
Yeah, I know this isn't a change, but someone tell us a bit about these license fees and when they were last updated?
I couldn't tell you off the top of my head when they were last updated. I know it's been quite some time. I can be more specific. I can get back to you.
Good.
Okay.
Representative Austin.
Is there any age for children that where they're free? If I have like a 7-year-old and 4-year-old grandchildren, and I'm really trying to teach them to fish.
There are mentored fishing days when you can fish with a mentor, but
They don't need to watch
Until 15.
oh,
Oh,
for
okay.
fishing, for fishing, right?
Yeah, because it said for person 17 years and under. So I just,
That's for hunting, right? Fishing licenses are free up until 15, then it's a reduced cost 15 to
it
17.
says fish. Right?
So,
Combination. What includes hunting.
Okay, it was just
Those are the current
confusing to
fees.
me.
Okay.
Yep. Thank you.
And then the department has some additional language that was not in here when we shared this, and I sent it over yesterday, and you probably didn't have a chance to see it, but I have hard copies. But if folks want them. This is an additional proposed revision. This is session law from 1999, when the state acquired the West Mountain Wildlife Management Area. And there was a lot of there were a number of restrictions associated with that acquisition related to the preservation of the camp leases that existed on the parcel. And the language that's in here required essentially the overhaul of a management plan every 10 years for this WMA. We're proposing to strike this requirement. The state has a long-range management process that we undergo that evaluates management of all of our wildlife management areas. And this 10-year requirement essentially was requiring sort of diversion of resources towards this particular WMA when it wasn't necessary and when we needed to prioritize other areas that required management. And the long-range management planning process is pretty involved. We currently have a long-range management plan for the West Mountain WMA, but we're just requesting the repeal of this particular requirement.
have the landowners involved in that area been engaged in the planning processes and remained active in this kind of dialogue that happens because of the planning process?
My understanding from talking to the public and private land management staff up there is that when the WMA was initially acquired by the department, there was actually a committee that involved the community members, and that it just sort of organically dissolved. It no longer meets. So there was initially community engagement in the planning, and interest has waned. And I think that they've been, my understanding is that the current long-range management plan, which does go through a public review process, has been satisfactory, and there hasn't been more pointed engagement from the community members here in recent years.
How often do you redo your long-range management plans?
Typically on a 20-year basis, but there is some revision right now within the agency. There's a long-range management planning rule that's in development that would be it's being spearheaded by the Department of Forest, Parks and Recreation, but it would apply to long-range management planning for all state-owned lands. So whatever that rule requires, it would be how we would implement planning at this WMA as well.
Thanks. Members have further questions? Thank you. We are going to take a 5-minute break, and then we are shifting